Thank you everybody for joining us today and welcome to Community Insiders, a speaker series that is designed to empower board members, community managers, and industry leaders with essential insights for effective community management. As Jeff said, my name is Claire Durham. I'm one of the directors of association services with Rosetta & Company. Today's topic is why updating your governing documents of your association is critically important. This CEU course is led by attorney Kerstin Henze from K. Bender Rambaum and guest speaker Frank Valdez from Get Quorum. With me is our marketing manager, Carla Castro, who will help moderate the questions and chats along with Jeff Salman. For those of you who are not familiar with Rosetta & Company, we've been in business since 1986. We're a full-service community management company, which is located in Tampa. We have 8 offices throughout the state of Florida. Whether your community is small or large, we're here to help. With our resources and dedication, we're committed to making sure you experience the highest level of service and success. With that, I'll go ahead and hand this over to Ms. Kerstin to get us started.
Great. Thank you, Claire. Good day. My name is Kerstin Henze, and I'm one of the attorneys with the law firm of K. Bender Rambaum. For those of you who are not familiar with the firm, we are a full-service community association law firm. So that means we exclusively represent your homeowners, condominium, and cooperative association. So we don't do any other practice area, so no personal injury, no criminal defense, only focused on community association. And as you may know, the laws have become more complicated over the years. So if you're happy with your legal counsel, that's great. But if you're looking to change, I would encourage you to really try to seek out a law firm that's specialized in this area of the law. I have been practicing law 17 years, and I've been with the firm since 2010. All right. So without further ado, let me go ahead and share the slides. And as Jeff mentioned, they will be provided to you, so you don't need to take copious notes. I'm going to, do you see them yet?
Yeah, we can see them. Thank you. And one thing I failed to mention is that if you have any course on topic related questions today, you're going to use the Q&A module, not the chat module, but the Q&A module. The chat module is where we're going to place the link for the evaluation a little bit later. Kerstin, back to you, my friend.
Thank you. So I'm going to go through my slides, and I'm going to leave some time towards the end for Frank to discuss electronic voting. I'll be discussing the process of updating your governing documents, some of the provisions that you might want to look in your governing documents to potentially amend. And these are just a few. You, of course, might have other provisions in your documents that you're looking to amend. But then we're going to talk about how to, effectively try to get a membership vote passed on these amendments. And so Frank will talk about e-voting. All right, so let's begin. First, let's talk about, when we're talking about amending governing documents, well, what are your governing documents? They primarily consist of three documents. You're going to have your declaration, and it's either going to be declaration of condominium or declaration of covenants, depending on whether you're a condominium or an HOA governed under Chapter 720 of the Florida statute. And then you're going to have articles of incorporation and then bylaws. Rules and regulations or architectural standards or guidelines, they are not considered part of your governing documents. They're what they are. They're just rules and regulations that are intended to supplement or clarify what's already existing in your documents. So when we're talking about hierarchy of your governing documents, your declaration is really going to be your supreme document. It is the contract between owners who buy into the community and the association, right? So it is a document that's going to contain primarily your use restrictions, what you can and cannot do, okay? So you might have pet restrictions, vehicle restrictions, so forth and so on. Those terms should be in the declaration. They really should not be in your bylaws. If they are, you might need to consider amending your bylaws to put them in your deck. Otherwise, you might be facing some enforcement challenges. And then your articles of incorporation and bylaws, these are documents that set out the corporate structure of your entity. As you may be aware, your association is a corporation. It is a not-for-profit corporation governed under Chapter 617 of the Florida statute, as well as either Chapter 718 or 720 or 719. And it's going to contain provisions such as, who qualifies as a member in your community, who qualifies as a director, how you conduct your elections, so forth and so on. Okay. And the bylaws are really going to be more of an extension of your articles of incorporation. So let's quickly talk about the amendment process before we look into some of the provisions that you might want to consider amending. So first thing is, typically, your governing documents will require membership approval. Very rarely have I seen provisions in governing documents that allow boards to amend without membership involvement. Okay. So there's two ways really to present amendments to your membership. One is at a membership meeting, and the other process is by the written consent process in lieu of a membership meeting. So with the membership meeting, that's what most of the board members are familiar with. That's where you notice a meeting. You either mail and post a copy of the notice on community property. You identify the agenda items, right? Identify date, time, location of the meeting. And then typically when you send out your notice of the membership meeting, you will include a limited proxy that contains the proposals that you want membership to approve, right? That's your traditional way. And your proxy, your limited proxy, which is the second bullet point, that limited proxy is good for 90 days from the date of the original meeting. So what that means is, if let's say your meeting is set, February 1st, and on that date you count your limited proxies, you count your ballots or your electronic votes, and you don't get the necessary membership approval that you need, well, the proxy gives you the flexibility to recess and reconvene that meeting for up to 90 days. And you can recess that meeting as many times as you want up to that 90th date, that 90th deadline. And in that time, you can knock on doors, send e-blast, do whatever you need to try to get the votes required. The written consent process acts very similarly to the proxy, except you don't need to have the membership meeting. So for most, this is going to be, a flexible option, especially if you're in a community where you have a lot of snowbirds or just a lot of residents who don't live in the community full time. So the authority to get a membership vote by the written consent process comes from Chapter 617 of the Florida statute, which is the one, remember I told you, it's the one that governs not-for-profit corporations in the state of Florida, including community associations. So essentially with the written consent process, you would send out a letter, a memorandum to the owners explaining what amendments you're looking to propose. And then at the bottom of that document, you will include a signature line. And so you will invite those owners who are in favor of the amendment to go ahead, sign at the bottom of the form, and then return the consent form. Okay. So under the statute, you have 90 days from the first executed consent form within which to get the membership approval. Now, the caveat is that with condominium associations, you have to have express authority in your governing documents to obtain this vote by the written consent process. With HOAs, unless you have language in your governing documents prohibiting you from taking a vote by the written consent process, you have the authority to do so. So check your documents to confirm that authority. All right, moving on. Distribution to members, that has to do with how are you presenting the documents to the owner. So typically you can do it by mail, hand delivery, or you can email the governing documents and either the notice and proxy or the written consent form to the owners but only to those who have consented to receiving notices in writing. Okay, so if you don't have written consent from an owner to receive official notices by email, then you would have to use one of the other methods. All right, and then the vote tally. The vote that you will need to get on the amendment will depend on the document that you're looking to amend. So if you're looking to amend the declaration, you will have to go to that specific document, find the amendment section, and see what is the membership approval requirement that you might need for that, okay? And you do the same thing if you're looking to amend the articles and the bylaws. Now, if your governing document or any one of them happens to be silent as to the membership vote that you need, then both 718 and 720 provide that you would need to get the approval of 2/3 of the membership. Okay. Now, you might be in one of those communities that might have a high threshold vote to obtain. So, for instance, your documents might require you to obtain the approval of 75% of the membership. And for some communities, that might be difficult to obtain. So as a practical tip, you might want to discuss with your legal counsel the option of first so amending that specific document to reduce the voting percentage required to amend the document in the future. And then once you amend that voting percentage and that amendment is recorded in the public records, then consider presenting substantive amendments to the membership for a vote. Okay. Now, material amendments. I just kind of want to point this out just so you're aware, but these types of amendments are typically very difficult to get approved, and so rarely do you amend the documents on these points. So typically material amendments are amendments that, for instance, will change the percentage of common elements that owners own in the condominium, or the percentage by which owners share or pay assessments. So if you ever want to change how much each owner is required to pay assessments, typically that will require the approval of 100% of the owners. And typically your declaration will contain a similar provision to the one that's in the statute, which addresses material amendments. I also want to point out to you amendments concerning leasing. Okay. So Chapter 718, which is the Condominium Act, had a provision put in, I wouldn't say 2004, and the HOA statute, Chapter 720, had a similar provision put in a few years ago, I believe 2021. So both statutes essentially provide that if you're looking to amend your declaration to either prohibit leasing in the community or to reduce the number of times you can lease, or how many times you can lease in a year. So any type of leasing restriction would only be effective against owners who vote in favor of the amendment, and then those who take title to the unit or the parcel after the effective date of the amendment. Okay, so you just have to be aware that when you're presenting a lease amendment to the membership, how you end up enforcing or against who you're going to enforce the amendment, will depend on, the language of the statute. Now, whether or not the statute will apply to your community, that gets us into Kaufman language, and we'll talk about Kaufman language in a few slides. So my recommendation is seek the advice of legal counsel whether these statutory provisions would apply to your community. Now, suspension of voting rights. When you're looking to get membership approval, suspension of voting rights may be a useful tool to help you get your amendment passed. And how it works is, well, under both 718 and 720, the board has the ability to suspend voting rights if an owner is delinquent on any monetary obligation owed to the association, if that delinquency has existed for more than 90 days. And then for condominiums, if that delinquency is at least $1,000. Okay, so if that's the case, you can suspend voting rights at a duly noticed board meeting. You don't need a committee to ratify that vote or anything. But once you suspend voting rights, the effect of that is that it reduces the percentage of votes that you would need to get the approval, as well as reduces the quorum requirement. So, for example, let's take a community of 100 units or parcels. And let's say, quorum is, 30% of the membership. Well, if you've properly suspended voting rights of 10 owners, then the quorum that you would need to achieve for that meeting is 30% of the 90 owners, not 30% of the 100. Okay, so it makes it more likely for you to establish quorum for that meeting so you can then proceed with getting the amendment votes. And similarly, if your, let's say your declaration requires the approval of a majority of the 100 owners, right, to get the amendment passed, and you've suspended voting rights of 10 owners, well, now you need to get a vote of a majority of the 90, not a majority of the 100 owners, okay? All right, and then mortgagee approval, not really going to go into a lot of detail, but just so that you're aware, many documents, and especially some of the older documents, might have a provision in the document that expressly requires you to obtain the approval of a mortgagee. In other words, the lender that has provided a mortgage for a unit or a parcel, specifically if the amendment somehow affects the rights or interests of mortgagees. So first, you'll have to determine if the amendment affects the rights of mortgagees or their interests or priorities. And if so, then there is a statutory process by which you would have to get mortgagee approval. Otherwise, if you record an amendment that hasn't been approved by the mortgagee, there is a potential risk of the mortgagee later trying to challenge the amendment if you ever try to enforce it. The risk is, potentially limited, but nevertheless, it's something that you should discuss with legal counsel before you record an amendment. And then just be aware that the statute of limitations to challenge any recorded amendment is 5 years from the date of recording. All right, so that's typically the process of amending. Let's talk about some provisions in your governing documents that you might want to consider amending. So the first one is, gosh, this toolbar is like in the middle. A foreclosing lender is required to pay 1% or 12 months of delinquent assessments. Is that true or false? Well, that is the safe harbor amount that's currently in Chapter 718 and 720 of the Florida statute. But is it guaranteed? And the answer is no. Just because the statute provides this amount, you're not guaranteed to get that. And that will depend on whether or not you have language in your governing documents that might provide mortgagees with greater protection than what is afforded in the current statute. So you might have language that says that if a mortgagee takes title to a parcel or a unit through their foreclosure procedure, and the owner happened to have been delinquent on assessments, well, that mortgagee pays nothing to the association, even though the statute has the safe harbor amount. So if you have that type of language in your declaration, then have a discussion with legal counsel because you might want to amend it out so that at a minimum, if a mortgagee forecloses and takes title, they owe the association the safe harbor amount that's in the statute. But again, remember when I talked to you about the possibility of having to get approval of a mortgagee? Well, this might be one of those instances if you have express language in the declaration that says you have to get mortgagee consent if the amendment affects the rights of mortgagees. Okay, so you'll want to look out for that. Okay, slide. All right. The next slide. The board has sole decision-making power when it comes to filing lawsuits. This is particularly for HOAs governed under Chapter 720 of the Florida statute. The answer is it's false. So that statement is false. And the reason is because Section 720.303 of the Florida statute prohibits commencing litigation against any party where the amount in controversy is over $100,000 unless the members vote to authorize that action. Okay, so Just be aware, if you're looking to pursue a legal action, whether it's an owner or a third party, and the amount in controversy exceeds this threshold, you will have to obtain membership approval to proceed. Next statement, all owners go through the screening process in our communities. Is that true or false? Well, it's generally false, but it will depend on your governing documents. So there's this misconception that, you know, your community is able to screen whether it's buyers or tenants just because, and that's just not true. Your authority to screen these types of applicants comes from your declaration. It's not something that's in the statute. It's something that has to be already in your declaration or something that you can amend to give you that authority. So go to the declaration and confirm whether or not you have the ability to screen these types of applicants. And if you don't, then you might want to consider amending if that's something that you're looking to do. If you currently have already documentary authority to approve, disapprove, whether it's buyers or tenants or other types of occupants, then I would, review the language, depending on when was the last time you amended or drafted that clause. Are there mortgagee protections in there? Typically there are, but a clause that I come across often, especially with the older documents, is that if a buyer buys from the mortgagee, they are exempt from the approval process. And maybe you don't necessarily want to have those type of applicants exempt. And so if that's the case in your community, then you might want to consider amending. You also want to scrutinize, well, who do you have the authority to approve or disapprove? Is it just buyers? What about tenants? What about additional occupants that move into the community after you have already approved the buyer or the tenant? Okay. What about gift transactions? If an owner bought the unit individually and later on adds another individual to the deed, do you want to have the ability to approve that transaction? Okay. So just some things you might want to consider discussing with your legal counsel. Moving on quickly. Oh boy. All right. Once the law changes, the change is automatically applicable to your community. Is that true or false? Well, as I put here, there are instances where the law will apply, generally if the new law is procedural or remedial in nature. However, the law cannot change fundamental contractual rights unless there's a compelling public policy need. So this has to do with what is known as Kaufman language, which I'm sure by now you board members have heard this ad nauseum because it has come into play in recent years due to the legislation that has been approved. So essentially, if the legislatures make changes to the statute that affect fundamental vested rights, okay, and that a good example of that is the change that took effect, I believe now in 2024, that states that HOAs under Chapter 720 cannot prohibit commercial vehicles from parking or work vehicles from parking in their community. Well, that is a change that affects a vested right of owners. So whether or not that change applies to your community will depend on whether you have what is known as Kaufman language. And Kaufman language refers to the magic words as amended from time to time, which typically comes right after reference to the Florida statute. And it's typically found in the first couple of pages of your declaration. And there would be a statement to the effect of, this community or this association is governed under Chapter 718 or 720 as amended from time to time. That language as amended from time to time means that any changes to the statute will retroactively apply to your community, and then you will be subject to those statutory changes. If you don't have that Kaufman language in your declaration, then you can potentially make a constitutional argument that those changes do not apply to your community retroactively, and the change that's in effect is the statute that was in effect when your declaration which was originally recorded. So you're not, subject to the new changes. And the basis of that argument is a, fundamental premise in the law that the legislature can't change contractual rights. And as you recall, your declaration is a contract. Okay, so when you're looking at whether a statute applies to your community, that's the analysis you want to do. And it is complicated, so definitely encourage you to seek legal guidance in that regard. All right, next one. Residents are prohibited from having clotheslines in your HOA. Well, that's false. There is this statute, section 163.04 of the Florida statute, that prohibits HOAs from enforcing documents prohibiting energy devices based upon renewable resources. Okay, so that includes your clotheslines and your solar panels. Okay, I think we're towards the end here. All right, the next statement is delinquent assessments accrue interest at the rate of 18% and a $25 late fee applies. Is that true or false? Well, it's true in the sense that both, 718, 720, and as well as 719, Chapter 719 of the Florida statute contain these provisions, okay? But with regard to late fees, the statutes provide that the association can only charge a late fee on a delinquent assessment if the authority is contained in your governing documents. Okay, so you have to have express language in either your declaration or your bylaws allowing the association to charge a late fee. Okay, and then with regard to interest, well, interest will accrue at the rate that's set forth in the document. So if you have some of the older documents that say that interest will accrue at 10% or 15%, well, that means that you're stuck with that percentage. You can't charge the 18% just because the statute says so. Okay, so if that is your case, then you might want to consider amending to allow you to charge the higher interest as well as allow you to charge a late fee and delinquent assessment. And typically when I assist clients in amending this particular language, rather than specifically identifying the interest or the late fee, I simply just give the board the authority to charge interest and late fees up to the highest amount permitted under the law as amended from time to time. This way, if the statute changes the amount, well, you're automatically going to be subject to the higher amount set forth in the statute without having to amend your documents. All right, and I think this might be the last one. A pipe in a wall serving a unit is a maintenance responsibility of the unit owner. Is that true or false? Well, it depends. So just because the particular pipe serves an individual unit, that doesn't necessarily make it an owner responsibility. You would really have to go to your declaration to review who's responsible for it, because those maintenance obligations, they are, really contained in your declaration. This is not really something that is addressed in the statute. So I would encourage you to review your maintenance obligations in your declaration and, confirm whether or not they reflect how you currently operate or whether or not you want to shift some maintenance responsibilities, whether from the association to the owner or vice versa. Now, obviously be aware that that will require some form of membership approval. All right. There's some kind of delay here in the slides. All right, here we go. So what have we learned today? Safe harbor mortgagee liability may be limited by old language in your documents. Powers ostensibly granted by the governing documents may be limited by statute. You may be losing money from interest and late fees. New laws may not apply to your association due to limiting language in your governing documents. And then if you have certain old language in your documents, they could potentially expose the association to discrimination claims. And that might be, for example, if you are not a community that is a housing for older persons community, In other words, you're not a 55 and older community, and you have verbiage in your declaration that says, children under the 18 are not allowed to permanently reside in your community. That could be problematic, okay, and could subject you to a discrimination claim. So take a look if you have that language, and then I would strongly encourage you to amend that out. Okay. And now I'm going to kick this to Frank to discuss electronic voting. All right, take it away.
Thank you very much, Kirsten. And wow, you are a wealth of information and knowledge. All right. I think we can all learn a lot here today. And so I know that we're telling a story, and uh, as you share kind of your contact information, so I'll let the folks know, please take a screenshot, get your phones out if you need that. I know the presentation's usually shared as well on Jeff's end. So thank you, Kirsten. Well, I know we're telling a story, so I will try my very best here to kind of tie it all in to electronic voting. While all of that information that Kirsten gave on, right, amending your docs and why amendments are necessary in association is almost our everyday as an electronic voting provider. We do have a lot of stipulations that associations have to follow for electronic voting. So I'll share a little bit of a slide here, do a super quick introduction for those folks on the meeting here, and try to keep it brief as well, because I see that not just the chat but the Q&A bubbling up, so I do want to afford plenty of time for questions. It will probably be a rapid fire round for Kirsten and myself at that point for Q&A, but I will leave enough questions as well. So we'll walk through some electronic voting, and keep in mind that I have obviously kept in provided some of the House Bill 913 updates as it pertains to these electronic voting statutes. So I just kind of want to walk through e-voting, what good looks like, how to use it for amending your governing docs, and what you need to make sure as an association that you're following. So quick kind of background here for those on the call today. My name is Frank Valdez. I'm the Regional Director for Get Quorum. We provide electronic voting services in the state of Florida. Been in this role for 5 years, and Get Quorum has served the state of Florida for 10 years now. Served on my own board of directors, several committees. They're actually trying to get me back on the board. I want nothing to do with that. I've served my time, I feel like, but more than likely I will be back at some point. Get Quorum, the company I represent, does provide this service to over 3,000 associations in the state of Florida. We do provide this service of electronic voting kind of as a holistic service, a one-stop shop. So do connect with me if you have any questions specific to your association, right? Beyond today's conversations, please do, and we can get into that. We've got some integrations that I'll kind of skip through, but I do want to start here. For those folks on the call today that are wondering, not just for amendments, but other areas where electronic voting, would be used or would be required, it is very popular right now. The popularity e-voting has gained over the last, 10 years, 11 years in the state of Florida, has been amazing. So whether you're levying amendments, special assessments, board, obviously board elections, there's so many reasons and ways that you can use e-voting in your community. So keep that in mind beyond today's conversation here. In terms of the basic, fundamental start for electronic voting, again, for everyone on the call today, understand that it's not just about going out and hiring an electronic voting provider. There are electronic voting statutes that we want you to follow to implement electronic voting, right? So I'm going to walk you through quickly here how to implement the tool of electronic voting in your community, so you have it in your tool chest, so that when you connect with your association management, right, the folks that, for example, Rosetta, and then you connect with your association counsel, you've got this tool in place to use towards amendments, right, as we tie everything up. So keep in mind whether you're our 718s, 19s, or 20s, right, your condos, co-ops, or HOAs, you do have to establish a resolution to allow electronic voting to be used in the community. So please, I implore you, connect with the association counsel to make sure that you are establishing electronic voting in your community per statute, right? So make sure that that is in place, a resolution, and that you understand that owners do have the opportunity to opt into electronic voting or not. That's usually what comes next after the board votes on allowing electronic voting to be used. So again, believe it or not, it is a board vote only to allow electronic voting to be used in your community. It does require that a notice be sent out, and it does require that a resolution be passed. So again, happy to walk you guys through that in more detail. If you'd like to connect with us, but do involve your association attorney in this process and management, because it is a collaborative effort. It is e-voting provider, management, and association counsel making sure that the e-voting option gets established, right? That switch is turned on. So keep in mind that the notice requirements have changed through House Bill 913. For example, condos now have a 48-hour notice prior to that resolution meeting taking place. HOAs, you're still at 14 days as of today, and co-ops as well. So you've got to make sure that this is done. Take a screenshot of those statutes as well, because we've got to all follow them on our end. Good news. E-voting is trending. We've got north of 32% of the communities in Florida. Obviously, as most folks know on the call today, legislation was adopted in 2015 allowing for e-voting. So it's been around for quite a number of years now. I think the best outcomes that have come out of this and is that we have some real hard statistics to lean back on now. North of 3,000 associations, to just give you kind of a sample case there, about 80% of the owners on average opt in. And this includes 55 and better communities. All right. So in Florida, whether it is our Century Villages, Boynton Beach, Leisureville, quite a few 55 and better communities, we're still seeing an over 80% participation rate, even in those communities. So when you have conversations like the one Kerstin just finished saying, hey, you may need 2/3, right, of your voting members. You may need a high percentage of ownership to cast a vote to get some of these amendments passed. The tool in the tool chest you're going to want to have established already prior to getting those amendments in the works is electronic voting, right? With the participation rates that we've seen with e-voting, the quorum percentages can be achieved. All right. So keep in mind that, again, there's some requirements, there's some things you've got to get out of the way first. And we want to make sure that we provide guidelines for that, and that association council does as well. Now, few things in the House Bill 913 came through that I kind of just want to pop up there to make you understand, especially for the condos on the call today, that there are some changes and shifts in how to implement electronic voting. I mentioned the 14-day requirement. Notice shifted to a 48-hour. There's some shifts and changes for unit owners petitioning electronic voting to be used as well. So keep that in mind. And most of the virtual meeting aspects like the one we're having today, keep in mind that you want to make sure that those are being recorded as well if you're a condo and being kept. So again, quite a few. We won't get too deep into the weeds on that, but I do want to make sure that at the very least, I kind of gave you a glimpse of what came down with the House Bill 913. In terms of best practices for amendments, right, just to kind of tie it in to what we walked through and what we went through today, in our world of electronic voting, you want to make sure you establish that resolution, get electronic voting, kind of the switch turned on in your community. Ask owners to opt in. That is a legal requirement here in the state of Florida. Owners must opt into electronic voting. Otherwise, they're opted out. They cannot vote electronically. So make sure you walk through those steps first, take care of them. And then when it comes time to executing your amendments, whether it is a limited proxy, as Kerstin mentioned earlier, or any other type of form, make sure you're communicating that notice and that information with your e-voting provider. So what we get a lot is management will contact us, state, hey, we've got a limited proxy that we're going to use coming up soon here for an amendment, whether it's a material alteration vote or any other type of vote. And we'd like for you to make sure that you send it out electronically to owners. Not a problem. We can send that out, collect those votes on your behalf, and then, of course, provide you with those results. To Kerstin's point, some of those proxies have flexibility up to 90 days. Electronically speaking, nothing changes. It is just a digital copy of what you would have been doing by paper. All right. So again, I implore you, connect with Association Council, connect with your management, and connect with the electronic voting provider that is going to be tackling these upcoming meetings for you, and make sure that you've walked through what good looks like, that you've rehearsed what the vote is going to look like. And again, we stand by for any questions, comments, or concerns as it relates to electronic voting here in Florida. Thank you.
Well done. Well done. Claire, I'm going to turn it back to you in just a second as our wonderful host for today. We thank you for inviting us to participate, by the way. Just real quickly, if you haven't already done so, please press the chat button so it appears on your screen, not to be confused with the Q&A. The chat module is different. We've already placed the evaluation link in there one time. If you haven't enabled your chat yet, you would not have seen it. So go ahead and do that now. We'll place it in there again in a couple of moments. The panel's about to get to the Q&A. They'll get to as many as they can
Yeah.
in the time that we have left. But keep in mind the required part, you went through the slides, and then after filling out the evaluation, the required part is completed, and we want you to hang out for the Q&A, but if you have another appointment, again, after the evaluation, the required part is over. Claire, back to you.
Thank you so much, Jeff. Kirsten, Frank, thank you guys so much for sharing your information and knowledge in regards to this webinar. This is so valuable for our board members, for community leaders, and other people within our industry. With that being said, I'm going to go ahead and turn it over to Miss Carla and Jeff for question and answers, and then I'll be back once that's completed.
Caller, we think you're muted, my
Yes,
friend. There you go.
yes. Do you see? There I go. Thank you for joining us today. And as Claire said, this was like really great webinar regarding documents. Some communities have really older documents. And I have a couple questions here. Um, Kim asks, would you if it would be helpful to have a flow chart on the voting issue? Like, do you need to give more graphics maybe so it helps understanding what's going on, or that's not helpful?
I mean, we can certainly consider, doing a flow chart or incorporating that into our slides for the future. So, I mean, I would just tell Kim, just be out on the lookout for next time we teach this class, and we'll try to update.
Yeah, I believe it's whether on the amendment that they're doing.
Well, I mean, if what she's looking for is confirmation at what percentage vote they need to amend, I mean, that's something that they'll have to take a look at their own governing documents. If she was referring to, my own, slides of kind of how I, outline things, I mean, happy to take a look and maybe update them a little bit next time.
Perfect. Then Sarah's asking, what if the amendment is challenged? I don't know if it's during the 90 days or after the 90 days.
Well, typically, a legal challenge would come after the amendment has been approved. And remember, the amendment is not effective until it is recorded in the public records. So a challenge will typically come once it is recorded. If you do receive a legal challenge, which will typically come in the form of a letter, whether from the owner or the mortgagee or their counsel, then forward it to your attorney and see, so the attorney will evaluate if there is good basis for challenging, and then what your options are at that point.
Perfect. Then we have another question from Troy. He's asking, how do they enforce their HOA existing leasing rules when the homeowner does not acknowledge that they are leasing?
Well, I mean, I think that's more of an enforcement question than an amendment question. I mean, we do offer a CEU class about enforcement. So, I mean, I think I'll just kind of, politely pass on the question since it's a little bit out of the topic.
No
I love that
worries.
you teased it though, Kirsten, right?
Yes.
She was like, we've got a class. I mean, it's perfect.
We got a class.
I
It's
mean,
coming too.
We do.
Make sure
When
he
in doubt,
visits.
we have a class.
Yeah,
Yes.
visit that KBR website because there's a ton of great classes there. So looks like candidate for your next class there.
Yes, we actually have an upcoming one with us too. So be on the lookout. We'll send you a schedule. And then Eric would like to revisit a little more the suspensions of voting rights. Can you elaborate on that?
So suspension of voting rights would come only if the owner's delinquent. Okay, and the owner has to be delinquent for over 90 days. And with condominiums, the amount of the delinquency has to be at least $1,000 or more. So, unlike suspending use rights or fining, which require a separate committee and then a 14-day hearing notice and all of that, suspension of voting rights is something that is done by the board at a duly noticed board meeting. Typically, you just post notice of that meeting 48 hours in advance, and you don't need a separate committee. So once you've suspended voting rights, you would notify the owner of the suspension, and then the voting rights would essentially be reinstated once the delinquency is paid. Okay.
Good stuff.
Okay.
So that's the process.
Thank you. And then I have another question for Stephanie. She's asking whether the ARC rule applies to the clotheslines.
Yes. So if you have something in your architectural guidelines or standards that address clotheslines, the statute would typically supersede those, and you wouldn't be able to enforce it. So, I'd have to take a look to see what exactly your ARC rules say about clotheslines. But typically, the statute would prohibit you from not allowing them in the community.
Okay. Angela has a question about the governing documents. What if the governing documents are so old that they are only listed FL 617, not FL 718 or FL 720? They'll have to amend everything, or?
No, well, the reference to 617 is the chapter that governs not-for-profit corporations. So typically it would be the articles of incorporation that reference 617. So it's not incorrect. It might just not be referencing specifically 718 or 720, but whether or not you are a 718 or 720, I mean, it would depend on your declaration, and declaration will typically say, condominium, we're a condominium governed under Chapter 718 or whatnot. So you wouldn't necessarily have to amend. Yeah.
Okay.
We'll leave it at that.
Then we have a question from Les. What does the right of first refusal mean?
Well, right of first refusal has to do with the authority of the board to approve or disapprove buyers. And again, we actually do have a class on that. So a little bit off topic, but essentially, if you want the association to have the ability to approve or disapprove buyers, the law says that you have to have a corresponding obligation to provide an alternate purchaser if the association disapproves for reasons other than good cause. Okay. And so this is why we offer a whole class on that, because it can be a little complicated. But essentially, the right of first refusal has to be in your declaration and has to do with the ability to approve or disapprove buyers.
Okay. And then how long does the voting can be open? Does it take a week, a day, the full 90 days if you don't reach the quorum, or how is that handled?
That's a good one. On the electronic voting world,
Yeah.
just to add, and the questions have been great so far. Even the off-topic ones, right? Just keep them coming. The process for us as an electronic voting provider is to fall back on those governing docs and walk through the timeline procedures that your association has already pre-established, right? So in our world as an electronic voting provider, we wouldn't change or shift how long voting is open. In the general, what we've seen here in the state of Florida is that for something like an amendment, something like 2 weeks or even a little bit more time is the open period. More than likely, the voting would close at the inception of that meeting, for which the changes are going to be made at. So whenever that meeting begins, usually voting is closed. opens, 2 weeks out, and it can even open further out. I can tell you this from best practices standpoint, the further out that you can open it, right, the wider the margin of the open period, something like a month. I've seen things
A
like
month,
30
30 days.
days open votes. That is not uncommon. Do not be afraid to consult your legal counsel for your association and say, how long can we keep this amendment vote open prior to the meeting? The 90 days, just to unconfuse everybody on the call, is a 90-day period after that original meeting date, should you need to recess and reconvene because you don't have enough votes, right? And that's what Kirsten was pointing to earlier, that if you get to the day of that meeting, you still do not have enough votes to pass the measure or the amendment, then obviously you can kind of shift and be nimble from there and keep it open for up to 90 days, depending on your recess and reconvene schedule. But prior to that date of that meeting, my recommendation would be 30 days. And again, I defer to association docs and pre-established meeting procedures in associations, because that is important. If you've got some pre-established already precedent for some of these processes, you want to go back to what you've done in the past. Digitally, we're just kind of mimicking the process.
Perfect.
Couldn't have said it better.
Yep.
All right. Thank you. Try to take a little bit of weight off. Kirsten's been like peppered with all these questions. Just want to make sure that we can help here. I need you to course correct me if you needed to. So
Of course.
Okay, yeah, we have a question here from Morris. He's asking, what if the declaration requires a majority of homeowners, but few come to the meeting? What options does the HOA have? That happens a lot. No one shows up actually to the
well,
meeting,
electronically
Yeah.
speaking, they count towards quorum, but so keep that
right?
in
The
mind. So if
votes,
you,
yeah.
if you're using an e-voting platform, more than likely you're achieving quorum through that e-voting platform. And then as far as a limited proxy, I just do want to, there's a proxy holder. Make sure it's someone like the secretary of the association, someone that's going to show up at the meeting and be able to turn in those limited proxies. So electronically speaking, very seamless, and you're usually not concerned about physical bodies, right?
Okay. Then I have more from electronic voting here. Um, what are the like? I think we went over these questions, but just to restate it, um, what are the requirements to get electronic voting initially agreed to in HOA?
Yeah, absolutely. So an HOA, and thanks for being specific there.
Mhm.
And again, you can contact me beyond this meeting if you have any questions from that HOA specifically. It's a notice of meeting, and in the notice and has to provide an agenda where the board will be voting on a resolution to authorize an electronic voting option for owners. So that's the first step there. You've got to notice a meeting. Secondly, a resolution must be voted upon by current board members, majority vote wins. And then beyond that, you make sure that you sign that resolution and keep it as an official record. Please, ladies and gentlemen on the call, keep those resolutions as your official record of the association. And then beyond that, usually the e-voting providers get involved with consents, right? Getting owners to opt in or out. I will take it back a step though and say that where does the process begin of implementing electronic voting in your associations? Contact your association counsel, involve them. I implore everybody on the call today to involve your HOA management, in this case, right? HOA management and your legal counsel. They've got to be involved in the process, because if you skip a step along the way, and those folks will make sure that you do not, then it really hijacks the whole process.
Perfect. We have another question from Karen here, and this is an interesting one. Can you do e-voting and mail-in at the same time?
It's a good one. Usually the response is yes. It's an either or, right? So either someone can cast a paper vote, or they can cast an electronic vote, assuming they've consented and opted in. You have to consent and opt into e-voting. Otherwise, you cannot cast an e-vote. It's an either or, right? So if an owner is not opted into e-voting, paper can be accepted. If an e-voter cast an electronic vote, that can be accepted. So usually in our world, it's about an 80-20, about 80% electronic votes and 20% paper. What is not allowed or permissible is a double vote, right? So if you're an owner that opted into e-voting, you should not be casting an e-vote and a paper, vote.
Mhm.
Obviously, it should be one or the other, but it is a hybrid process right now in that paper is still accepted for owners that wish to remain outside of electronic voting.
Okay, perfect. Here's another one that is good, and there's a couple actually about kind of price and percentages. Um, it's a difference between, doing e-voting for a smaller association rather than large association. Um, which is best, either, emailing it or e-voting or mailing it, depending on the size of the association.
Yeah, definitely. And that's a great question, Carla, from that person. Look, in the world of electronic voting, we've got associations as small as 16 doors. And I thought to myself, well, I can probably knock on 16 doors, right? Give me about an hour and I can
Exactly.
knock on it. And then they kind of like straighten me out really quick and letting me know, the property manager, this is an investor only property and they're overseas somewhere. So they're not going to show up in a meeting. They're not living in those units and they cannot cast a vote in person in these meetings. So it made sense for that association to adopt electronic voting at a cost per, something like a few dollars per door, right? It would be something like under $500 for an association of that size. On the larger scale, right, we've seen 8,000 door communities like Babcock Ranch over in Fort Myers say there is no way that we can deploy any of this voting for 8,000 doors without digital options,
Exactly.
right? So we've got kind of both. I was shocked with the 17 until again they gave me a little bit of background and saying these owners aren't here. They're not even in the state, so we do need electronic voting. So whatever your situation is, check in with us.
Exactly. I think it's a mix of both that it's advisable nowadays, depending on, how's the average of your association. If you have people that are more renters and, owners live out of state or things like that, and they cannot attend meetings. And so both are advisable. I have another one question from John, and probably this is more for you, Kirsten. Can you summarize again the rules for making material changes to the property?
Summarize rules for
Yeah,
material
I think
changes to
yeah,
the property. We're talking about like material alteration.
material alteration apparently, yes, material changes. Yeah,
Um, well, I mean, you know, the statute says that you would need for material alterations performed by the association, you need a vote of at least 75% of the owners unless otherwise provided in your governing document. So that means you obviously have to look at your governing document, see if they address material changes or alterations. And if they do, what is the percentage? Because if it's 75% or, even 66 and 2/3, that might be too high for your community, depending on what you're trying to achieve. And so you might want to consider amending your declaration to reduce the voting percentage you need to obtain from the owners in order for the association to do material alterations. But then also, is what you're trying to do really a material alteration, or is it more in line with a necessary maintenance obligation of the association? And that line can sometimes be,
Lord.
in the gray. And so I would first confirm with your legal counsel, whether or not it is in fact a material alteration, or does it fall under the maintenance exception? And if it is a material alteration, then, possibly consider amending your declaration.
Yeah, that's true. And then we have the last one. We have really great questions here, and we can go all afternoon if we
Yeah.
start asking one. But this is regarding does the clothesline issue apply to condos or just to HOAs?
Any community, any
Both,
community
basically.
association. Yeah.
Great.
I love the hot topic
Yes.
became the clothesline today. The hot topic for today was the clothesline. I actually thought it was going to be you had electrical panels there, right? So the
Yes,
solar
I thought it
panels.
was going to be like
I thought it
those.
was going to shift to that because in my community now, as you drive the main road, they're
Oh,
front
yeah.
facing. So they face the garages in the front. You see them from the street. But because of the way the sun phases, you can, like, that is what it is. They have to be able to put them even forward facing, as ugly as they might look in some cases. So clearly, we are more upset about clotheslines than we are about solar panels these days.
Well, thank you, everybody. What a great webinar and what a great Q&A. You know, I loved hearing the questions about electronic voting. I assume that's from the most recent season of the annual meetings. And furthermore, coming into the new year, we made it through the budget and the annual meeting season in your first month. And the new year, January, it's much easier to breathe if you're an association manager or a board president. So diving right into your association documents to review them, such as policies or amendments. This is the time. So I want to first and foremost thank you to our panelists, Frank and Kirsten, of course, Carla and Jeff. Thank you so much for sharing your time and your knowledge with everybody. And thank you for everybody who is on and who attended and asked these great questions. With that being said, if you would like to refer to these slides or share them with your community, this presentation will be posted on our website, rosetta.com/blog, as well as our YouTube channel and Vimeo within the next 72 hours. Thank you again for everybody for attending and investing your time to make the community where you reside a great place to live and for others to work together and enjoy. I hope everybody has a great rest of your day. And if there's anything that you guys need, please don't hesitate to always reach out to us or your association legal attorney.